Hey everyone, it's Rob Ryder on Sunday, May 12th, 2013. And interesting little tidbits have come up in the last few days since talking about doing business as and registering your business, which is your all caps, and then claiming to be its owner by giving the owner's name as your true name. And this is written in their laws. It's something we haven't done. Because we haven't done it, they say we're breaking the law, and therefore we cannot have access to the courts to bring any action against a contract, in a nutshell. So, reasons to register your DBA. Well, first of all, what the hell is a business? Because you're going to be doing business as. In Webster's 1828, it defines business as that which occupies the time. That which occupies time, period. Right? That can be considered a business. Business is also any temporary employment. Okay? Good. That's one we're getting to the one I like. It's a serious engagement, important occupation, in distinction from trivial affairs. As he defined, it should be the main business of life to serve God and obey His commands. It should be the main business of life to serve God and obey His commands. And we're doing name, we need to do our business under a fictitious name in their system. And we just haven't claimed to be the owner. And so we're what's known as an unknown owner. In Illinois, the county clerk is the trustee of all unknown owners. We're going to fix that. So that's what a business is, something to be done. To do the business for a man is to kill, destroy, or ruin him. Well, that's what the trustee is doing right now. The county clerk is killing you by doing your business, because you're classified as an unknown owner. So one of the things is real and true name. We're going to find this all over the place. They want you to use your real name or your true name or however they happen to say it, but what it is your surname coupled with a combination of the individual's given names and initials. Rytlewski coupled with a comma to Robert Allen is my real and true name. I'm not a junior. If I was a junior, that would be my initials. So, when you fill it out as the owner is Rytlewski, comma, Robert Allen. The corporate, not the corporation, the company, the business is Robert Allen Rytlewski, all caps. And so we can find all sorts of things about this. And let's start here real quick, because this is the first one to look at. It's pretty telling. Okay, so this is my certified copy of record of birth, and it says Robert Allen Rytlewski, now remaining in my office and the whole thereof, which means the corporation hasn't been split, the company hasn't been split. Viz, which is short for Vildaset, which has something to do with a determination or a decree from a jury, but child, right? Robert Allen Rytlewski is the child. Okay, now let's go look at some rules that's going to apply to. That's what it says in Arizona. Now in Arizona, they don't have a doing business as form as such. When you contact the county, they say you get it from Kinko's or some legal forms supplier. But in a nutshell, what it says, anyways, is any person other than a partnership transacting business in this state. And the partnership, I think, is if you're married. See, if you're married, that's a partnership, and that one has probably been properly certified and put in the record. But we haven't claimed our own ownership of our private estate yet. So any person other than a partnership transacting business in this state under a fictitious name or a designation not showing the name of the owner of the business or the name of the corporation doing such business shall record with the county recorder of the county in which place of business is located a certificate stating in full either or, okay, and it's the county in which the place of business is located. The name of the owner of the business and his or her place of residence, signed by the owner and acknowledged. If a corporation, we don't need to worry about that. A new certificate shall be recorded upon any change of ownership of the business using a fictitious name unless such business is a corporation. New certificate shall be recorded if a corporation. Don't need a corporation. But a person or corporation doing business contrary to this section shall not maintain an action upon or on account of a contract or transaction made in the fictitious name in any court of the state until such person has first recorded the certificate required by this section. In other words, you can't claim to be the owner until you claim to be the owner. Otherwise, if you haven't done it, you cannot bring an action. And that's why the best we can ever get out of these courts is a dismissal. And a dismissal is nothing. All it means is somebody else can come try later. All right? We want it discharged. We want our property back. We want them charged for fraud. All sorts of things that can happen other than a dismissal. And the reason they can't happen is you haven't recorded your name, and so they put it in the statute, which they're using for an instrument of fraud, contrary to natural equity or natural justice. But be that as it may, it's the way it's set up. Shall not maintain an action upon or on account of a contract. So you can't make it an issue that the deed of trust or the mortgage that you've signed that they haven't signed, therefore it's a unilateral contract, not a bilateral contract. And bilateral contracts are what are used in commerce because we haven't claimed to be the owner. We're an unknown owner. Why I showed this to start with, because here's the child, Robert Allen Britluski, which is a fictitious name. In Arizona, it says the court may order upon request of any interested party that the child to be adopted shall be referred to by a fictitious name in all proceedings before the court. Such would be the best interest of the child. If the court by order authorizes the use of a fictitious name, the real name of the child shall be kept in a sealed envelope in the court file and shall not be opened except on order of the court after good cause has been shown. Well, I think we're foundlings, right? We were abandoned property, basically, right? And somebody is our co-parents, because they have these co-parency statutes, codes, definitions. And so we were adopted under a fictitious name, and our real name is being kept in a sealed envelope in the court file. And this says, a copy of the record of birth of, now remaining in my office, the whole thereof. And who has this? Well, it's Stephen Toth, clerk of the county of Bay, and the circuit court thereof. So in the court file and the circuit court thereof, apparently still in Bay County, because to me, what we're looking at here is the initial registration, and because of the date, 29th of July, 1963, and I was born in 1958, come September 5th, it will be 5 years. If I haven't renewed this, then it's going to be considered abandoned property. So I never did renew it. Therefore, it's still remaining because I can go to my birth county and still get this. Well, I don't know if I can get this one. But you go to your birth county to get your birth documents or copies of them. It means that's where they're still at. In the court. Under a fictitious name. Robert Allen Britluski. And what's my real name? Britluski, Robert Allen. What's my birthplace? Bay City, Michigan. All right, so that's my business place, I guess, Bay City, Michigan. All right, so they're going to keep your real name in a sealed envelope, right? We want the mail in a court file and shall not be opened except on order of the court after good cause has been shown. It's a Class 2 misdemeanor for a person to knowingly display, cause or permit to be displayed, or have in the person's possession a canceled, revoked, suspended, fictitious, or fraudulently altered driver's license. Your driver's license is in the name of all caps. It's a fictitious name. All right, so boom, if you have a driver's license, you're guilty of a Class 2 misdemeanor. To knowingly display, oh, I already did that one. Yeah. To knowingly use false or fictitious name in an application for non-operating identification license, or to knowingly falsify other information required by section whatever. Make a false statement, conceal material facts, or otherwise commit fraud in application for non-operating identification license. Anytime you put something under your all-cap letter name and you haven't gone ahead of time and recorded your DBA, filed your DBA, had it indexed as a DBA, you're breaking the law. That's what they say. So, let's see. What did Florida? Okay, so we'll look at Florida here. Hopefully. Don't see that anymore. Okay, so in Florida, this is what Juan did. This came through the state, right? Application for registration of fictitious name. He put his all caps name up here. He put his address here. Now, somebody asked me, should it be all caps? What I'm going to say is, whatever address they're using for all caps, that's where you're going to send it to, or that's what you're going to use as the address. Just use it the way they put it on the envelopes. It's the post office told me that they get your address from the county. And if that's the case, the address they're getting from the county is the address for all caps, because we haven't filed to be the owner yet. Once we do, we're going to give the owner a postal address. Okay? You had to put the name of the county here, but he didn't put any FDI number. And then owner's name. Look at last name first, M.I. Now, they want you to think M.I. means middle initial. And I don't believe it does. I don't believe you go to a legal abbreviation or dictionary that M.I. means middle initial. But I bet you M. means middle and I. means initial. And that's what it said. Your surname coupled with your given names, S, first name and middle name, and then your initials if you're a junior. So Juan put the same address, because it's okay that you have the same address as your business. What matters is that they know if they want to address it to the owner or to the business, they're going to put your all caps in as who it's being addressed to. And if it's addressed to the owner, it will be to Rytlewski, Robert Allen. And that's all he had to do. Do the bottom, send it in. Got a certificate. Got a letter. The letter came from the reinstatement division of the Secretary of State. He took this form, put it in a court case, and said he was there as the owner to settle the matter. When the judge started the case, because the attorney wasn't in when he did this, when the attorney shows up and they start the case, and the attorney starts the spiel, he would start it probably every other foreclosure he's ever been involved in. He's got his script down really well, except as he's going, the attorney turns to Juan and says, do you object to that? I don't even know what he said, right? That Juan didn't even tell me what he said. But the judge looks at Juan and says, do you object to that? And Juan said, yes. And he said, or she just said, sustained. I'm sure that caught that attorney way off guard. And then she said, here's what we're going to do. We're going to stay the proceedings for 30 days until Juan here gets an attorney. And apparently the attorney started to speak up, and she shut him down immediately, making it very, very, very clear that this case is over. And so when Juan was walking out to the hallway, the attorney runs up to him and says, what did you put in the case? He says, I'm going to send you a copy. No, I demand to see it now, whatever. So I said, okay, Juan said, here you go. And he looked at it, and it was this certificate, or the certificate they give you for this application. And the attorney says, oh, so you're misrepresenting your position. I'm going to go take care of this now and reset the hearing. And he told Juan, you wait right here. And Juan said, I don't have time to wait. I got stuff to do. Anyways, nothing's ever been heard from the attorney again since that day, and not only in this case, but in 3 other cases he had going. He hasn't gotten any more mail on any of these matters. And So that 30 days was up, and they were supposed to have another hearing, so Juan was going again to represent himself. He got there late. They'd already had the hearing. You know, say, oh, shit, what are they going to do? I'm not here. Right? And so the court said, you're going to have to wait and find out in the mail. You know, he. Well, when he gets the mail, the order was that the judge denied the strike of Juan's affidavit he had entered that the opposing side was asking for. They denied the motion to strike the affidavit. And it was either that hearing or the first hearing, because the affidavit had already been put in, where the judge said to Juan, says, they were talking about his affidavit, said, you'll be able to use this in the future. And then we have this thing happen in this next hearing where they don't strike it, which means that Juan's affidavit stands as truth and that the attorney has to answer, and that's why they ain't sending him any more mail, right? They're running away from this as fast as they can. And now that we've made this a corporation, being all caps, that you're the owner of, contesting a contract issue with another, forget that I said corporation. If I say corporation, for us, we're not a corporation, we're a company, but it's just hard to not say corporation sometimes. It's a company, it's not a corporation. If it was a corporation, they wouldn't be able to come directly after its officers like they do by charging you with a misdemeanor for not having done this. So now it's one registered company against another registered company. And it's commerce, and in commerce, both parties have to sign the contract. Right? Go look at a contract book. If you can find where you can do a contract with a corporation without both parties signing it, show it to me. Right? Because they're charging you with a debt. Well, if there's a debt, we had to have a contract. So, now let's look at some laws that they have for Florida. This is off the frequently asked questions page. It was on the Florida website, apparently. Again, you know, Juan sent it to me, and I see what it had to say. A fictitious name means any name under which a person transacts business in the state other than his legal name. Anything besides your legal name. So it's good to know what your legal name is, and it's good for them to tell us. In Florida, they consider your legal name to mean your given name. If you're using anything besides your given name, it's a fictitious name. Using anything besides your given name, it's a fictitious name. And why do we do this? The intent of the Fictitious Names Act is for the public notice as to ownership. Who is exempt? Attorneys licensed to practice law. Notwithstanding the provisions of any other law, registration of the Fictitious Name Act is for public notice only and gives rise to no presumption of the registrar's rights to own or use the name registered, nor does it affect trademark, service mark, trade name, or corporate names, rights previously acquired by others in the names or similar name. So this is one step of a multi-step process, right? In Michigan, you start in the county. In Florida, you started at the state, but you have to let the county know that you've done this, and I think in Michigan you need to let the state know that you did this. But not only that, you need to let the federal government know you did, and now you're going to take your doing business as fictitious name and make it your trade name. And so it is for public notice only, right? So now the public will know that you're the owner, and gives rise to no presumption of the registrant's rights to own or use name registered. Because right now somebody else has taken your all capital letter name and they're saying they're the owner. What happens when you don't do it? Are there any penalties? Well, guess what? Failure to comply with the fictitious names registration provisions of this section, 865.09, right, go read that, is a misdemeanor of the second degree and punishable as provided in, I bet you that's the criminal code, 775. Well, I need proof of my fictitious name registration. As a prerequisite to receiving local occupation license under the chapter or transferring a business license under something else, the applicant or new owner must present to the county or municipality that has jurisdiction to issue or transfer the license either a copy of the applicant's or new owner's current fictitious name registration issued by the Department of Corporation, which is basically what Juan has. And so this is saying now you need to go and present to the county or municipality that has jurisdiction to issue or transfer the license. Somehow, because you're doing it at the state, you need to let the local government know also. Also, banks and financial institutions may require proof of registration before engaging in any transactions. Juan, I think you need to take yours down and give it to your bank and see what they do with it. Tell them you're the owner. Does the fictitious name need to be advertised in a newspaper? Yes. The name of the registered must be advertised at least once in a newspaper as defined in Chapter 50 in a county where the principal place of business or applicant will be located. No proof of advertisement is required. As part of the signature block, the applicant certifies the name as advertised at least once in a newspaper as defined in Chapter 50. Whatever. I go read Chapter 50. I think from reading other states where you do this, you need to take that back also and have it filed with the county clerk in your public notice, right? Because this is supposed to be acting as public notice, right? So where's the public notice file? So a little more work to do with, with what Juan has, but he already got a court to stay his proceedings. That's beautiful. Let's look at Massachusetts. In Massachusetts, you go down to the town hall, and you get something that looks like this. And they want you to print in black. So some people have asked me, what color do you print it in? Well, here they're saying print it in black. Is it a new issue or renewal? Again, these are renewals. We've already had the initial, and it's at your birth county because that's where your birth documents still are, under a fictitious name, and in a sealed envelope is the name of the true owner. And we want to get that frickin' envelope. In conformity with the provisions of, so again, this tells you what sections apply, right? All caps, address. Following persons, name, print. True name, Britluski, Robert Allen. Residence, same address as all caps. However, residence is one of those funny words because it's not the same as address. They're using residence. And so what is the residence? What is the residence? It depends on how they define residence in Massachusetts, right? So you need to go to Massachusetts and see what's the definition of residence and put it in. And they want to know the type of business. Well, what type of business is this? Well, one is, doing the work of God, as Webster says, following his laws and commandments. But another one could be asset management, asset protection, estate management, property management. And in all cases in this, you're the owner. Okay, so now you take this down and boom, that's been done. Now, they wanted you to do one more thing here. They want you to go and put one in to the local police department. Norwood Police Department, business site listings. Complete name of business, complete address, business phone numbers, right? So basically, you would take a copy of what you've already done with the city or the town, and I would take it with this form and take it over to the police department. But you can see we're not using UCC1s. They have forms they want you to use for this. They didn't say use a UCC1. It has nothing to do with the UCC. These are forms from the county. And whatever entered IMC means, you're going to be entered into some system, which isn't bad, right, to show now that you're the owner. We want the world to know we're the owner. That's the idea. And in Massachusetts, any person conducting business in the Commonwealth under any title other than real name, which is, last name, comma, first second, or first middle, shall file in the office of the clerk in any city or town. An office of any person or partnership may be situated, stating the full name. So this says city or town, right? They want you to file with the clerk in every city or town a copy of this. And it shall be executed under oath. All right, so now they got to call you a liar. And violations of this shall be punishable by a fine not exceeding more than $300 for each month during which the violation continues. $10 a day they're charging you because you didn't file a certificate to do business under an assumed name. That's how Massachusetts does it. And looked at this one before, but I'd like to look at this. This is the one for Kent County, where I'm at. And so this would be a renewal, name of the business, address. It says it's the complete mailing address. Names of persons owning, right? It doesn't say that you're the administrator or the executor. You're the owner. And if the county clerk is the trustee of all unknown owners, then there's no reason he can't be the administrator for all known owners, so appoint him your administrator. It's one of the things we're supposed to do when you claim a domicile in Michigan. You were supposed to be able to appoint the township supervisor as your and board as your administrators and attorneys. So name is, again, the real name. We'll look at the laws and go with this. But this bottom part right here is the same as what was on my certified copy record of birth. Right? It's got a testimony statement, the clerk's name, deputy clerk, and a seal. It's got a testimony statement, county clerk, place for the deputy clerk to sign, and place for a seal. So they're going to certify this, and it will be the seal of the Court of Record. Circuit Court of Bay County, Michigan. Now, Tom did this here just not too far recently, and he got as far as having a form similar to this in his county, because, again, each county has their own, under the seal of the Court of Record. But I think they skipped a step, because they're doing it the way they always do it, right, by custom instead of by law. And the law is MCLA 445.1 to 445.5. And I don't think they indexed it properly. So we're going to go back and see if that's what they did. And let's see here. It had to be in there. Yeah, here's the laws. So it says, in Michigan, file in duplicate in the office of the clerk of the county. So we need to make sure we're in the office of the clerk of the county. And not so much the county clerk's office, but the office of the clerk of the county. A certificate in the form furnished by the county clerk, setting forth under the true and or real name, right? Last name, comma, given name. You're going to pay $6 to have that done. And then the county clerk shall certify the duplicate and return it to the applicant. So what they've just given you is your owner's certificate of title. And they've kept the original certificate of title, which is an exact copy of the owner's certificate of title. And it shows that you're the owner. So you've already certified that you're the owner. What I don't think they're doing, though, is they're not indexing it. And then after 5 years, you got to do it again. You got to pay $4. If you don't, it's going to be considered constitutes abandonment of the assumed name. Well, not just the assumed name, of the business. That's what we're talking about. You've abandoned the business. And they can reject it if it's too close to another name. However, I'm going to walk in with that certificate I have and say, well, I know I'm the owner. Here's my certificate from the original certification. And anytime you change your business location, so my birth county was Bay County, and now I'm in Kenton County, so I did change the business location. And so it looks like you have to have a certificate stating the change in business location. Now, who has this certificate? Where does it come from? I think I can use my copy of the certified copy of record of birth, and say, well, here's the original, right? And here is where I'm at now. Maybe that's the certificate they want. I don't know if everybody has one of these or can get them, but they had them at one time. Certified copy of record of birth. Robert Allen Rutluski, Robert Allen. I say it's my property, and there's a record, number 2137 in Lieber F, page 2137. Date of record is October 7th, 1958, which is the sealed envelope they're talking about, in my opinion, because I was born on September 5th, right? So now we're 32 days afterwards. And what else do we have here? Assumed name discontinuance of operations certificate. When assumed name concern shall go out of business, it shall be the duty of the person or persons who have conducted such business to file a certificate, clerk of the county or counties which the contract transacts businesses of discontinuance of operation. I think we're talking about your loved one's death certificate, and that needs to be filed just like these other certificates do with the clerk of the county to terminate the business. Because once the business is terminated, and the owner's shown up saying he's terminated the business, well, now the estate that was supposed to come to you can come to you, your inheritance. Because the inheritance is everything that isn't given by will. And the county clerk shall keep an alphabetical index of all persons filing a certificate provided for in this act, and for indexing and filing of the certificates shall receive a fee of $10. Okay? You're going to get a fee of $10. A copy of the certificate duly certified by the clerk, in whose office the same is filed, shall be presumptive evidence in all courts of law. That's why we want it into the clerk of the court of record. Upon payment of $10, the payer shall be entitled to 2 certified copies of the certificate without extra charge, with additional copies of $1 each at the time of filing the original certificate. So the main thing is, see, on this form, there are too many things open now. On this form, it says filing fee $10. Certificate expires, and it's going to have a filing fee of $10. Well, I want to add indexing and filing. County clerk shall keep an alphabetical index of all persons filing certificates provided for in this act, and for indexing and filing of a certificate shall receive a fee of $10. Really want to make sure that it's been indexed and filed, not just filed, because that will make it presumptive evidence in all courts of law. And if you don't, but any person or persons failing to file a certificate required by Section 1, shall be prohibited from bringing any suit, action, or proceeding in any of the courts of this state in relation to any contract, this really sounds like Arizona, or other matter made or done by such persons or persons under an assumed or fictitious name until after full compliance with the provisions of this act, which is to file the damn name. All right, now, Illinois. There are lots of interesting things in Illinois, but real quick, I'm going to show you where they self-confessed in Illinois in just a second. Here's an assumed name certificate for County of Kane. List at the top, the compiled statutes that go with it. You can go read what it says to do, right? Name, address, nature of the business, property management, asset protection, estate manager. It is sort of the true and full names of all persons owning, again, owners, right? True and full name, last name, comma, given name, with the respective post office address of each. See, and this is where we're going to put a post office address. And what do they want you to use for a post office address? It says the house, street address, city, state, zip code. So just put it on there. And so in Illinois, you have to do this form, and at the same time, because you're going to get this from the county, you're also going to get, well, I need to look at, where was that one? I had to get this one off the line, right? Copy of legal notice to be published. That's the interesting thing. Look what office this came from. Assumed name unit, vital statistics. Go figure. Assumed name unit, vital statistics is involved in this. But this is the form that looks like you fill out to take to the newspaper. Under the assumed name of, with the business located at, and put the true names of the owners. Anyways, you fill out two forms with the county clerk, and then you take it to the newspaper, and I think you give them one of the forms, and they go ahead and they run the ad, and when you get done, they give you a certificate, and you get an original copy of the ad, and you take that stuff back to the county clerk after it's all been done, and then they put it into the record. So it's a little bit different process. But let's look at their rules real quick. Right? No person or persons shall conduct other than a real name. So, and here you can't do it in any name besides Rytlewski, Robert Allen. In Florida, Robert Allen, because they said the legal name is the given name. But here they said the real name, and the real name is the, by definition, the surname coupled with the first and middle. It shall be published in a newspaper. It shall be published once a week for 3 consecutive weeks. The first publication shall be within 15 days after the certificate is filed. So you're going to file the certificate. Within 15 days, you have to have it into the newspaper for the first time. Proof of publication shall be filed with the county clerk within 50 days from the date of filing the certificate. So from the time you put the certificate in, you have to have had it in the newspaper for 3 consecutive weeks and return it to the county clerk. Upon receiving proof of publication, the clerk shall issue a receipt to the person filing such certificate, but no additional charge shall be assessed by the clerk for giving such receipt. Unless proof of publication is made to the clerk, the certificate of registration of the assumed name is void. So you don't have any choice. And again, always talking about the post office address for the person, for the man, for the real name. The several county clerks of the state shall keep an alphabetical index of all persons filing certificates pursuant to 1 and 2, when 1 was the fictitious name and 2 is the publication. And for $5, then they will put it in alphabetical index. Right? Until you get to this point, you're not done. A copy of such certificate and receipt for proof of publication, duly certified by the county clerk in whose office the certificate is filed, shall be presumptive evidence in all courts of law in this state of the facts therein contained. And it's going to say that you're a registered owner. And if you discontinue your business, wishes to withdraw his name from business, organization, shall certificate canceled, opposite the trade name, right? So they're going to call your fictitious name now a trade name, and a trade name can be registered with the federal government, I believe. It'll become your Pepsi-Cola. Got to be careful about misrepresentation. And this doesn't apply to any corporation, so we're not corporations because this doesn't apply. And you got to include the true, real name of persons or persons transacting said business, nor shall it be construed in any effect, subdivision of sections of the criminal code. Right? So we got a couple sections of criminal code to see how they apply to this particular thing, but basically, if you haven't registered your DBA, you're breaking the law. Yeah, it doesn't need to be for express trust. Instrument in writing under which title the trust property is vested in designated trustee or trustees. However, the problem with express trust is, for it to be truly a trust, as the trustor, myself and the trustee are going to have a contract between ourselves that he is the trustee to administer the estate for the benefit of somebody else. But we've both signed a contract. You don't have anything for anybody showing that they've agreed to be your trustee, even though you would consider yourself the trustor. So what that kind of trust is, it's an unexecuted use, which means you don't have an agreement between the parties. The trustee hasn't agreed to be your trustee. But you gave him the legal title anyways, right? So now he has, and he says, hey, I got the legal title, I'm the owner. He's not acting in good faith. And if you don't do this, you're guilty of a Class C misdemeanor. And it says peace officers don't need to put this in. That's interesting. Have to look at that closer later. But this is how they get you in a court case. This is very telling. If a person or persons required to register hereon or do not do so, and such persons or any of them are unknown, civil actions may be brought against such persons or persons by filing a suit against the business under its assumed name, under all caps, by naming all known owners and designating as unknown owner or owners the other persons or persons transacting business under such assumed name. Okay, now there's something I want to look at that goes with that. And so we're going to look at Brown's case. This is Rose Friend from Cook County, which is where Chicago is. And Cook County's got a big chancery division. And so Roe and Brown went down and asked to see the chancery file, and this is what they got. And so here is how it started out. PNC Bank, National Association as Successor in Interest to Mid-America Bank, FSB, is the plaintiff, versus, there's all caps, right, so it's being done under the assumed name. But look at who the defendants are. PNC Bank, N.A. Right, a different form of this up here, but certainly different, therefore a different organization. Unknown owners and non-record claimants. Under its assumed name, naming all known owners and unknown owners. Well, who did they name? They named PNC Bank as a known owner of Brown, all caps. Well, that means PNC Bank is pretending to be Brown. And they must have signed something saying that they are. Or else how could they have been put on here as a known owner? Because they don't have on here, you don't see Brown's real and true name, so he's not known as an owner. He would be considered an unknown owner. All right, so let's go a little bit deeper. A judgment rendered pursuant to this section shall be a personal judgment against all name owners and shall, in addition, be immediately enforceable against the property of the business and constitute a lien upon real estate held in the name of the business. So it will be a judgment, personal judgment, against all named owners, period. Let's see how they handled this one. Watch this. Okay, this is August of 2011. And notice the court cases all run together. Notice here that it's not run together. And this is from February 15th, 2012. Right, so from August to February. Now, again, this is in the Chancery file, and when Roe asked Rowan if he had seen any of this paperwork, most of it he hadn't seen before. Well, look at what it says. So there was an order given in February, and it says, this cause coming to be heard on plaintiff's motion for default, and the court having found the defendants have failed to appear and or plead, it is hereby ordered that the defendants, right, the corporation, is in default. It is further ordered that unknown owners, non-record claimants, are dismissed as party defendants. That should have released Rowan right there. He's an unknown owner. He's not listed on here. He's not listed on here as the defendant. His corporation is. A suit may be filed under its assumed name. The suit's against the business. And they've released the unknown owners, and they don't have Rowan listed as an owner, so he'd have been an unknown. But it gets better. On the same day, another order, a summary judgment. This cause coming to heard plaintiff's motion summary judgment against PNC Bank, right? Because PNC Bank, N.A., is a known owner. They're written down here as a known owner. And the court finding no material issue of fact has been raised, it is hereby ordered that summary judgment is granted in favor of the plaintiff against the defendants, PNC Bank. So the court found for the plaintiff this form of PNC Bank against the bank in the other form. Right? That's who's guilty. That's who the judgment was against PNC Bank. But because of this now, they're going to put a lien against the real estate enforceable against the property of the business and constitute a lien upon real estate held in the name of the business. So now they just put a lien against your property, and you still don't even know any of this happened. At any time prior to satisfaction of the judgment, if any, if the identity of a previously unknown owner is discovered, such person shall be named as a party defendant by motion to the court in which such case is pending or in which the judgment was entered, supported by an affidavit showing that the notice of such motion has been given in the manner required for service of process upon an individual defendant by civil practice law. So now that they've given this judgment, but prior to a satisfaction, they're going to come find you and say, hey, you're an unknown owner. And they're going to say, did you sign this? Is that your signature on this deed of trust? And if you say, yeah, that is, well, boom, guess what? You were doing business as under an assumed name where you hadn't registered to be the owner. But apparently PNC Bank did. And now they're going to drag you into this. So all this other shit's already happened before you ever get to court. But it has to be done by an affidavit. See, they can't do it by a certified mail. There has to be an affidavit showing that notice of such motion has been given in the manner required for service of process of an individual defendant by the civil practice law. Now, they're the ones who put civil practice law that way. I don't know if that's something specific to Illinois or not, but there is a proper way to give notice. And in Michigan, if you're putting the notice of motion in, well, you send the notice of motion attached to the motion, and that's what you need to give to the defendant or to whoever you're serving the motion on. And then there's a proper way to do it. But this is saying they have to do it by the affidavit method. And they don't have an affidavit showing that they've given you proper notice. So right now, PNC Bank, the court case was against them. So in this case, Drone should take this in and say, well, you've already filed against PNC Bank. And by the way, I am a known owner. So he needs to go register his name, put it on there, and say, how is it that PNC Bank is claiming to be the owner of my estate? We'll figure that part out. But then, so at the same time, because this led to there being a lien against the property, now we're going to appoint a selling officer and sell your property. And this is all based on the fact that PNC Bank, N.A. SII to Mid-American Bank, whoever the hell that is, these people have said that they're the owner of Brone, all caps. And now they're going to drag you in as an unknown owner and say that's your signature. They can pin it on you. It will become a judgment against you, and the fraud continues. If the defendant does not file an appearance within such 10-day period, or if after hearing the defendant is found to be liable, the judgment, if any, theretofore entered in such suit shall be amended to include such person, and shall at such time become a personal judgment against such person, as if he had been individually named to the original complaint. And all this happens because you have not filed a DBA to say that all caps is your property and you're the owner. And the owner, true name, is what they're looking for, is your surname coupled with your first and second, your given name. If you put true name into Google and look at some of the things that are in there, that they talk about all this fantasy stuff, a lot of games and so forth, but even like in the Lord of the Rings, the idea is that if you control somebody's true name, you control their power. And that's exactly what's happening. And right now, in Arizona, the fictitious name of the child for the child, the court has authorized its use, and the real name of the child shall be kept in a sealed envelope in the court file and shall not be opened except under the order of the court after good cause has been shown. You go in and you claim it on this. So here's what I think we do, right? We go in and we do the DBA and get it done, and then we send a copy of that to the chief judge of the county and say, hey, I'm the owner. I want to have the records. And then he can issue an order. See how that works out. Okay, so there's more than meets the eye, right? There's much more than meets the eye, and those that have a problem with doing this stuff, I don't know what to tell you. I'm not going to worry about it. I'm going to tell you what a business is. It should be the main business of life to serve God and obey His commands. And His commands are point out the transgressors. Right? We got to clean up the Garden of Eden. Got to pull the weeds. It's time to burn them. This is the great revelation going on. So let's go claim our property and, kick Satan out of town. Oh, what a wonderful day that'll be. Because to do the business for a man is to kill, destroy, or ruin him. And right now the county clerk is doing all the business for the unknown owners. And we're going to make him not be the trustee. We're going to make him the administrator. Great stuff. And your true name, surname of an individual, coupled, comma's a coupler, with combination of individuals' given names and initials. That's my opinion. I say that a comma is a coupler. If you don't think you need to put a comma in there, don't. I think it needs to be there, because that's how they put it on my original document. So, okay, we're going to leave it there. Y'all have a great day.